The webinar will begin in 3 minutes. The webinar will begin in 2 minutes. The webinar will begin in 1 minute. Welcome everyone, and thanks for joining us for today's webinar entitled Minors as Beneficiaries, What Could Go Wrong? The webinar will last approximately 15 to 20 minutes, and at the end you will be given an opportunity to receive supporting materials by email. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning law practice in Franklin, Tennessee. Linus also runs the publication Think About It, founded by life insurance industry guru Steve Lineberg, and Linus regularly speaks at industry events. His latest book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, which was written together with a CPA and a business broker, is now available for sale. Linus will draw on his legal, tax, and life insurance background and his practical experience for today's webinar. And here he is.
Thanks, Jennifer, and thanks everyone for joining us today. We're going to talk about minors as beneficiaries, and we'll get to that in a minute. But I know that a lot of you are preoccupied, as we are, with the fallout from the CARES Act and also the Secure Act, both of which were passed earlier this year. And there's a lot going on there. And so next month, rather than voting on what it is that we're going to talk about, we're certainly going to talk about the updates to the CARES Act and the Secures Act. So on Wednesday, August 5th at 11 a.m. Central, we'll talk about that. If you haven't already subscribed to our YouTube channel and you're not getting notifications from us about upcoming webinars, please do so. And you'll make sure that you can see the topics and plan to attend the topics that are of interest to you. But we'll talk about CARES and Secure Act next month. Before we actually get into the minors as beneficiary topic that we're going to talk about today, let's talk at least a little bit about the breaking news. The IRS last week published Notice 2020-51, and the service did some interesting things in that notice. What it did is extended the normal 60-day rollover deadline for all eligible rollover distributions previously taken in 2020 until August 31st. Now, we at Advanced Underwriting Consultants had been telling people that if somebody took an RMD in January, they couldn't do the special rollover relief where the previous deadline was the tax return deadline, July 15th. They were kind of stuck. Well, the IRS said, no, if you took a distribution in January and you thought it was an RMD, you can still roll it over. And so, that's good news for a lot of our clients who thought they were potentially out of luck. Another surprise as part of that notice was that distributions that were previously taken by beneficiaries of inherited qualified accounts, including non-spouse beneficiaries, if they took amounts that they thought were RMDs earlier in the year, they are also allowed to roll those amounts back into the inherited account by 60-day rollover, assuming the carrier permits it. That's something that's never been allowed before, at least in our experience. We don't remember anything like that ever having been allowed before. But a non-spouse beneficiary can redeposit an RMD into an inherited IRA. Another bit of good news is that amounts rolled over because the notice permitted them will not count against the one 60-day rollover per year limit that applies to IRAs. So that's good news as well. So be aware of that as you're working with your clients. Make sure that they understand that this is an opportunity. It is something that you can do during the summer here in July and August. You can touch base with all your clients who may have taken distributions earlier this year, whether their own or beneficiary distributions. They've got an opportunity to do a rollover where perhaps they thought they didn't have that opportunity before. So it's certainly something to talk about. So I wanted to make you aware of that. We'll talk about that again next month, and we'll talk about some other details about the notices. But this one was particularly important from our perspective. So let's go ahead and talk about minors as beneficiaries. We've hit on this theme before if you've attended some of our webinars. But just in the nature of a review, there are several problems that can arise when a minor is named the beneficiary of a life insurance policy or a beneficiary of any financial instrument, really. But we're in the context of life insurance, so let's talk about life insurance. And the biggest issue has to do with collecting the death benefit. The minor doesn't have the legal capacity to be able to sign until the minor is of age. And so since the minor can't sign the paperwork and can't collect on the minor's own behalf, somebody's got to go to court to collect the money on behalf of the minor. The process for doing that is a guardianship of the estate or a conservatorship for the benefit of the minor. And it requires somebody who's an adult to petition the court to seek permission to act. And while that sounds good, in the abstract, it is a process that can involve expense and inflexibility. What do I mean? Well, the first potential issue is that if members of the family are not in agreement about who it is that should be responsible for the money, the court proceeding could be contested. And that means that it could take longer, could cost more, and could deplete assets that might otherwise be available for the minor. The second thing is that once somebody petitions the court, if the petition is successful and the guardian or conservator is named, the guardian is going to have duties and responsibilities, including reporting to the court and perhaps to other family members about what's being done with the money. And sometimes the guardian is going to have to get the court's prior approval for spending money, perhaps for investing money. And in a lot of cases, the courts are conservative in the kinds of investments that will be allowed, and won't allow the guardian to invest in things like annuities or permanent life insurance, even if those things make some sense, because the court doesn't see them as being conservative and safe investments. And so from our perspective, the question is, should the concerns and the potential difficulties prevent a life insurance professional from naming a minor as the beneficiary of a life insurance policy? I don't know if prevent is the right word, but certainly somebody should think twice or three times before naming a minor as the direct beneficiary. And we're going to talk briefly about a court case that reinforces how hard it can be and what kinds of things can go wrong when a minor is named the beneficiary. So let's talk about the Sampson case, which is a Mississippi case. The court was asked to rule on a situation where the life insurance death proceeds were payable to minor children beneficiaries. And Jeffrey Warneth bought a life insurance policy from Unum, $336,000 in change, for the benefit of his three kids, including two minor kids, Jeffrey and Shelby. Now, the minors resided with their mother, Shannon, and Shannon was divorced from Jeffrey. And of course, the reason that we're talking about this case at all is Jeffrey died, and this became a life insurance claim. So Unum issues drafts payable to Unum issues drafts payable to the guardians, and the policies are mailed directly to the ex-wife, who is the guardian, and she deposits the fund into her personal account. Well, the court didn't tell Unum, or didn't order that the proceeds be sent that way. The court ordered that the proceeds be sent to the court so that it could be redistributed to the guardian. Well, the Unum sent the money to Shannon directly, and Shannon, instead of creating a guardianship or custodianship account for the minor kids, puts the funds into her own account. And you can probably guess the rest of the story. Shannon later misappropriates the fund. It's a nice way of saying that she steals the funds from her kids. And the kids don't get their dad's money. And so later on, a representative for the kids files a complaint against Unum, also against Shannon's bank, alleging negligence, breach of contract, and some kind of tort breach theory. The complaint against Unum is that they did it wrong. They sent the money directly to the guardian instead of sending it through the court, and thus Unum didn't follow the right procedures. And so the lower court, the trial court, dismissed the case against Unum, saying that because Unum was not a party to the guardianship proceeding, it couldn't be liable for not doing things the way that the court ordered. The children appealed to the Mississippi higher court, and on appeal, Unum says, "Hey, We sent the money to the guardian of the children's estates, and therefore their contractual liability was satisfied. The children said no, Unum did not follow the requirements of the guardianship order to the letter. They failed to send the money to the court. They sent the money directly to the guardian instead. And therefore, Unum increased the risk that the money would be lost, and they shared responsibility for the children's having a financial loss. So that was the shape of the argument. And so the Mississippi Supreme Court analyzed the facts and decided the trial court was too hasty when the trial court dismissed the kid's complaint against Unum. They pointed out that by sending the checks to the guardian directly, instead of sending the checks to the court, Unum created this extra risk, and that the trial court could find in favor of the kids because of Unum's creating an extra risk in the proceeding. And so the case was sent back to the trial court for full proceeding on the merits. Usually when that kind of thing happens, the parties end up settling because it's expensive to do a full proceeding. They end up settling along the way. So it feels likely that Unum will have paid something or will end up paying something in this circumstance. So why would the parties have gotten into this situation where the minors were beneficiaries and, ex-wife ended up misappropriating the funds? Well, the first thing that happened is something that's understandable if you've been in the life insurance sales process for more than 10 minutes. So any life insurance professional that might have been involved here and the insured would have believed that naming the minor kids as the policy's beneficiaries was a better idea than any alternative. We've got the insured who was divorced, who wanted his kids to get the money. So makes sense that the kids would be the beneficiaries. And, if the insurance professional, didn't think it through about, the consequences of naming minors the beneficiaries or the possibility that minors would be in line to collect the money, then, that kind of set up the situation in the Sampson case. Once Jeffrey, in this case, passed away, the minors and their family members would have wanted to collect the money quickly and painlessly. And so a process was needed for them to collect the money, but also to protect the minor beneficiaries' financial interests. And the insurance company would have wanted to pay, a fail-safe way to only send the money once, right? If it sent the money directly to the minors, since they're not capable of signing for it, when they come of age, they could have sued Unum and potentially won and collected a second time. So Unum was interested in making sure the money got to the right people and that it was going to be off the hook. And so in the Sampson case, Mom, the ex-wife, petitioned to become guardian of the minor's estate. How does that protect the kids? Well, we talked about it earlier. The court supervises, at least in theory, how the money is spent and how it is invested. And the insurance company, if a guardianship is established, then the insurance company is protected when it follows the rules of the guardianship. It's off the hook. It's paid the money according to the rules. And then, that way it only has to pay the money once. Now, in this case, Unum didn't follow the rules, at least arguably, and therefore is potentially on the hook for extra. So the family wants to collect the money quickly. The insurance company wants to be sure it doesn't pay the money out twice. And so in a lot of situations where you've got minors as beneficiaries in line to collect the money, there's an automatic tension. This exists in all these types of cases, not just the Sampson case. And if you've been in a situation where minors were beneficiaries of a life insurance policy you were helping the family with, you've probably run into that situation. Family wants the money quickly. Life insurance company says, not so fast. We don't want to pay twice. So, that's the situation, that's the backdrop with regard to the Samson case and its fallout. Well, what could they have done differently? Well, on the front end, one approach would have been to take more care with the beneficiary designations. Jeffrey could have created a testamentary trust for his kids in his will or living trust documents, and that trust could have been named the beneficiary of the life insurance proceeds. And to make things even tighter, Jeffrey could have named somebody who wasn't his ex-wife the trustee of such a trust. In a perfect world, that would be the answer in nearly all cases. Well, the world isn't perfect. Folks don't like to go see lawyers for whatever reason. And not everybody will spend the time, effort, and money needed to create even a testamentary trust, even though in a lot of cases, the trust is exactly the right solution because it is flexible in terms of how it is operated, and it is flexible in terms of who is the trustee of such a trust. But for whatever reason, that wasn't done in this case, but it certainly could have been done and could have been better. In the alternative, Jeffrey could have taken advantage of ready-made custodianship rules without the need for somebody to go to court later on by using UTMA. And the right words in the beneficiary designation invokes UTMA and allows the preferred custodian to handle the death benefit on behalf of the kids. And if you've called our office, you may have heard us use these words before. The right words in beneficiary designation are name of adult custodian as custodian for name of minor under the State Uniform Transfers to Minors Act. And if you've got those right words in the beneficiary designation, and the carriers may want you to craft those things slightly differently from what we've given you, but these words seem to work nearly all the time. If you got those right words in the beneficiary designation, UTMA is invoked and no custodianship is needed. And in theory, the UTMA custodian hangs on to the money and uses it for the benefit of the kids. In this case, Jeffrey could have named somebody who wasn't his ex-wife as custodian for the minors, and presumably that custodian would have done a better job in handling the money for the benefit of the kids. Now, what could have been done differently post-claim in the Samson case? Obviously, Unum should have sent the claim money to the court rather than directly to the guardian, to the ex-wife guardian. Presumably, once the court clerk received the money, the court would have invested the money conservatively, probably in a CD or treasury instruments or something like that. The court could have also been a more active overseer of what the guardian was doing, and perhaps could have prevented Shannon from misusing the funds and making sure that Shannon provided evidence that distributions were for the benefit of the kids only. And then, if there were worries in the family that Shannon was going to waste the money, somebody else in the family could have volunteered or contested Shannon's petition to act on behalf of the kids. All of those things would have ended up with a situation where the post-claim result could have been better. Those are all things that perhaps if you're working with a family post-claim or dealing with the insurance company post-claim, those are all things, all alternatives that perhaps you should be aware of. So what is it that we should take from the Samson case? Well, I think the first lesson is this, and it's an important lesson, and that is that making the easy choice on the front end may make things more difficult later on. We certainly understand how difficult the life insurance application process can be, and sometimes the amount of time spent on the beneficiary designation is less than 30 seconds. Naming minors as beneficiaries on this particular policy was easy. However, when the insured died, things became difficult with the custodianship, and ultimately the waste of the death proceeds for the kids, and the kids' money was lost, and so they ended up having to sue in order to try to collect it. From our perspective, the clear lesson is this: don't name minors direct beneficiaries if you can help it. For situations involving large amounts of money, large amounts of death benefit, our clients should consider creating trusts, perhaps testamentary trusts for the benefit of their minor kids. When creating a trust is not the practical solution, folks should consider using UTMA so that the money is preserved for the kids with the custodian of the insured's choice. And the last idea is one we've hit on many times in the past. Beneficiary designations control the transfer of much of the cash wealth that our clients have at death. It might be more cash wealth is controlled by beneficiary designations than by any will or trust document. And so as we're working with our clients, it's up to us to make sure that the beneficiary designation is crafted carefully in a way that is consistent with what it is that the client wants to do. I'd like to thank you all for attending today, and I'm going to turn the program back over to Jennifer, who's going to wrap us up. Jennifer?
Thanks, Linus, and thanks for joining us today. And join us next week for an update on the CARES and SECURE Act. If you would like to receive supporting materials, feel welcome to email me at asktheexpert@advancedunderwriting.com. Again, that's asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar to me. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact me at 615-224-1291. Again, that's 615-224-1291. Thanks again, and best wishes for continued success.